Thank you very much, my Lord. My Lord, the position in summary as to where we are, we would submit is this, that the cornerstone of the appellant's argument is that FSMA constitutes a complete code for the authority's functions, and that in particular sections 401 and 402 provide an exhaustive list of the offences for which it may prosecute. But on the basis of the submissions we made this morning, we say that argument collapses when we look at the primary legislation in the Industrial Provident Societies Act, the Building Societies Act, the Friendly Societies Act. And the appellant's only answer is to say those provisions predate the Financial Services and Markets Act, and that the prosecutorial powers are now subsumed by the Financial Services and Markets Act. But in truth, that is no answer for three reasons. First of all, in relation to that earlier legislation, the authority's role as a prosecutor is contained in amendments to those acts brought in to effect by the Mutual Societies Order, which came into force at the same time as the legislation. Secondly, the previous legislation does not confer any power to prosecute. It was assumed that the prosecutorial power existed. And thirdly, there are no deeming provisions either under those acts or under the Mutual Societies Order which deem the prosecutorial powers as being exercised under the Financial Services and Markets Act. So
could you just say the third one again?
There are no deeming provisions either under those acts, my Lord, or under the Mutual Societies Order which deem the prosecutorial powers to be powers exercised under the Financial Services and Markets Act. So we submit that the cornerstone of the appellant's argument simply goes on the basis of that. But, my Lord, may I then...
Well, as I understand your argument, is if you start at the beginning with the creation of the authority, there's nothing in its memorandum or articles of association which deprives them of prosecuting powers, although one can think of extreme cases where it might be argued. My treason one was an example where the memorandum did provide a limit to prosecuting powers.
Yes.
And then, as I understand that, with that as your starting point, you then look at the legislation to see if there's anything in the legislation that takes away what would otherwise be there. And your submission is that there is nothing which takes away powers. There are provisions in these various statutes and regulations that we've been looking at, which in effect provide privileges or which limit the powers of other people to prosecute. And in that context, when you come to the Financial Services and Markets Act, you read sections 401 and 402, and they make perfect sense, and would not make perfect sense if read as supplying powers to prosecute rather than limiting or granting privileges or requiring the requiring compliance with directions from the Treasury or the Secretary of State or whoever it may be.
Yeah.
That is your case.
Yes, thank you very much, my Lord. And
I got it right.
Exactly.
Kind of you.
Yes, no.
The starting point, in one sense, is the Act, because the Act confers functions.
Yes.
And the memorandum, or whatever it is, the Article of Association, are then drafted, not surprisingly, in order to conform to the functions which have been conferred under the statute.
Yes.
I mean, that's the way around it has actually worked.
Yes, Lord, that's right. Although the statute is not exhaustive of the functions that are conferred.
No, I mean, but it does talk about with a view to or a connection with the transfer to the company of all functions applied.
Yes.
So and so, or functions pursuant to any other law or any regulation from time to time having effect in any part of the United Kingdom.
Yes.
I mean, it says whatever we give it a function under it, we've got we meet, and that's how you'd expect it to be drafted, isn't it?
Yes. That's exactly it, Lord. And Lord, the appellant's argument is no, it's a complete code, but that can't make sense for the reasons already indicated. My Lord, may I just turn to deal with the point in relation to the Proceeds of Crime Act and the powers of investigation without seeking to push it too far, but turning to Volume 1, Divided 12, because the starting point is the Proceeds of Crime Act. And the purpose of going to the Proceeds of Crime Act is the purposes of this submission is to identify the central role of accredited financial investigators, because as your lordships will see, the authority has been designated as an accredited financial investigator. And the starting point in Divided 12 is Section 3 of the 2002 Act, which appears at page 134 of the bundle. And your lordships will see from Section 3 that the National Policing Improvement Agency must provide a system for the accreditation of financial investigators. Then subsection 2 is what the system must include provision for. And then subsection 3, a person may be accredited in relation to the Act or in relation to a particular provision. And subsection 5, a reference in this Act to an accredited financial investigator is to be construed accordingly. And then if we go on to page 136, we can see some of the things that accredited financial investigators can do, because if we look at section 42, which is actually in the part of the Act that governs applications for restraint orders, your lordships will see that under section 42, subsection 1, a restraint order may be made only on an application by an applicant falling within subsection 2, and then 2C, the applicants fall within this subsection, 2C, an accredited financial investigator. And if your lordships wish to make a note, I will demonstrate that includes the FSA. So the FSA can seek a restraint order, and then section 43 is appeals to the Court of Appeal. This is appeals to the Court of Appeal Criminal Division. And if a Crown Court decides not to make...
which section is it?
Section 43, my Lord, appeals to the Court of Appeal Criminal Division. If on an application for a restraint order the Court decides not to make one, the person who applied for the order may appeal to the Court of Appeal. And so that would include the FSA. So the FSA can appeal to the Court of Appeal. And then section 45 at page 138... 45.1, if a restraint order is in force, a constable, an accredited financial investigator, which for these purposes note FSA, or a customs official may seize any realisable property. And then section 289 at page 141 of this bundle, if a customs officer, a constable, or an accredited financial investigator is lawfully on any premises and has reasonable grounds for suspecting that there is on the premises cash which is recoverable property or is intended by any person for use in unlawful conduct, and the amount is not less than the minimum amount, he may search for the cash there. And if we just go back to section 241, we can see what unlawful conduct means. That's at page 139. It's effectively anything that's criminal in the United Kingdom, or if it occurs overseas, it would be criminal if it in fact had occurred in the United Kingdom. So it's a sort of transposition exercise. And what the effect of that is that accredited financial investigator, your lordships will see, includes the FSA. The FSA may seize cash under Section 289 where it's derived from any unlawful conduct. So it's not an offence under the Financial Services and Markets Act. It's in relation to any offence. And there are other powers granted to accredited financial investigators. Your lordships can see that at 2893, 2894. And then Section 290, just so that your lordships see how it works, in certain circumstances, prior approval is required for conduct under the Act. So, for example, 290 subsection 1 says the powers confirmed by Section 289 may be exercised only with the appropriate approval, unless in circumstances it's not practicable to obtain that approval before exercising the power. And then subsection 2, the appropriate approval means the approval of a judicial officer, or, if that is not practicable in any case, the approval of a senior officer. And the significance of that, my lord, is, I'll demonstrate to your lordships in a moment, that there is within the scheme a distinction is made between officers within the FSA and senior officers within the FSA. So the FSA may approve within the FSA the actions of an accredited financial investigator. So it's just to bear that in mind, and when we come to look at the statutory instrument. And then Section 294 is the seizure of cash, again, accredited financial investigator. But perhaps most importantly for the purposes of this submission is Part 8 of the Proceeds of Crime Act, which is Section 341 at page 155 of this bundle. And, my lords, just by way of passing, just before I look at Section 341, at page 153 and are the money laundering offences, or the two principal ones, concealing and under 327 and arrangements under 328. But those are the principal money laundering offences. But your lordships will see that Part 8 is concerned with investigations, and 341 at page 155 deals with the nature of certain investigations under the Act. And for these purposes, the important provision is 341 subsection 4. For the purposes of this part, a money laundering investigation is an investigation into whether a person has committed a money laundering offence. And then for these purposes, perhaps I could just give your lordships the references, because it's not included in the bundle. But if your lordships just wish to make a note there that money laundering offence means an offence under Section 327, 328 or 329, and that is made clear by Sections 415 and Section 416, subsection 9 of the Act, which are not included. But the essential point to note is that a money laundering offence is an offence contrary to 327, 328 or 329. And then we see that under Section 352 at 157, there is power to obtain search and seizure warrants, because 352 is an example of a power where a judge may, on an application made to him by an appropriate officer, and that appropriate officer for these purposes is defined in 378 which is at 161 of the bundle, and it includes at 378 subsection 4 in relation to a money laundering investigation, an accredited financial investigator. So for these purposes, the FSA is an appropriate officer. So a judge may, on an application made to him by an appropriate officer, for these purposes read FSA, issue a search and seizure warrant if he is satisfied that either of the requirements for the issuing of the warrants is fulfilled. And your lordships can see from 3522, the application must state a person specified in the application is subject to a confiscation investigation, an exploitation proceeds investigation, or a money laundering investigation. So you could get one of these if you're investigating 327, 328. And then by reason of subsection 4, a search and seizure warrant is a warrant authorising an appropriate person to enter and search the premises specified in the application, and then and to seize material. And then appropriate person is defined in subsection 5 as a constable, an accredited financial investigator, or a customs officer if the warrant is sought for the purposes of confiscation investigation or a money laundering investigation. So the FSA can get these warrants and act upon them. They can get the evidence in relation to money laundering. And your lordships will also see at 352 subsection 7 that the reference in paragraph A or C of subsection 5 to an accredited financial investigator is a reference to an accredited financial investigator who falls within the description specified in an order made for the purposes of that paragraph by the Secretary of State under section 453. Now, the important point to note is that these financial investigators have power to investigate the offences which are being prosecuted in this case. And then if we go to the actual order that's been made, it's in this volume at divider 24, and it's the Proceeds of Crime Act 2002 references to financial investigators, Amendment Order to 2009. And just so that your lordships know, there was an earlier order, which is behind divider 23, which was made earlier in 2009, but for various reasons it had to be amended because it wasn't, it didn't cover the whole field. But that's just historically, it's relevant because the 2009 order amends the earlier one. But just to look at in divider 24, your lordships will see that made October 2009, came into force 2nd of November 2009. And the Secretary of State makes the following order in exercise of the powers conferred by Section 453 and 4592. Those are not in the bundle, my lord, but so that your lordships know, 453 is a section that contains the power to make an order designating who is to be within the term financial investigator, and 4592 just contains general rules in relation to subordinate legislation, but they're not material. And then just going on to Article 4, it substitutes Schedule 1 of this order for what had been in the earlier order. And then if we just go through the schedule, it can be done very quickly because your lordships will see how it works. In column 1, there is the provision of the Act, and we've just been through them. So, for example, 42.2c is the restraint order provision. So an accredited financial investigator may apply for a restraint order. And your lordships will see in column 2, on page 346 of the bundle, at little Roman 6, is the Financial Services Authority. So there's the Financial Services Authority. Then, just dropping down column 1, section 45.3, is the seizure of property to which a restraint order applies under part 2, which is that seizure of property. Again, just going over to page 347, at little Roman 3 is the Financial Services Authority. Then 68.3c, which is not in the bundle, but it governs the power to make applications for restraint orders or appeals under section 43, 44, 65 and 66, which is effectively appeals to the Court of Appeal and to this court, to the Supreme Court. And page 348, little Roman 6, the Financial Services Authority, and is not below the grade of manager. So for those purposes, there's someone who's not below the grade of manager. Then
are you going to solemnly take us through every one of these? Do we need that?
No, my Lord. It's just the important one, my Lord. There are certain ones in relation to Northern Line, but your Lordships will see at page 354. There are certain powers in relation to Northern Line, but at 354, my Lord, is the Part 8 investigations, and your Lordships will see Financial Services Authority. That also can be picked up, my Lord, in relation to various other powers. So that's the point, my Lord. And so that deals with that. So the short point is there is a power to conduct money laundering investigations. So the symmetry argument simply cannot be right. And in any event, the symmetry argument, it cannot, the power to prosecute cannot depend on the availability of powers of investigation.
Are there any specific powers to prosecute in this statute, POCA? Or does it simply not deal with them?
My Lord, there are no specific, it doesn't say this person may prosecute, so far as I'm aware. And then, my Lord, so far as private prosecutions are concerned, may I, without repeating, merely adopt what's in our printed case at paragraphs 25 to 34, where we set out the statements of principle from the relevant authorities. In relation to the appellant's argument in relation to section 1.4 of the Financial Services and Markets Act, may I just adopt what's set out in our written case at paragraphs 56 to 59 at pages 78 to 80 of the appendix. And in relation to the deeming provision argument, my Lord, I don't want to waste time. But in the short point is that there is nothing in the Mutual Society's order which deems the prosecutorial functions under the earlier legislation to be functions pursued by the FSA under the Financial Services and Markets Act. So, and in that particular order, the references to, it's in the supplementary bundle, the relevant amendments to the Friendly Societies Act can be found at page 35 of the bundle and page 54, using the page numbers at the top. The amendments to the Building Societies Act can be found at pages 61 and 62 of the bundle.
Sorry, can we just...
I'm sorry, Lord.
Slowly, please.
I'm
page
sorry.
54,
Page 54, using the page numbers at the top, my Lord.
Yes.
If the starting point, my Lord, in relation to that is page 35 of the bundle, where your Lordships will see it's the amendments to the Friendly Societies Act. And the point that we make, Lord, is that in paragraph 54 on page 35 is the part that is to be substituted in relation to functions of the authority. But what it's not doing is saying nothing about prosecutorial functions. And then at page 54, which is paragraph 109, that's the provision that says in section 107, which we looked at before the short adjournment, the word commission, wherever it appears, there is substituted authority. So, my Lord, the simple point is this, is that the functions are being conferred on the authority, but it's saying nothing about the prosecutorial powers in those acts, because it doesn't need to, because as with the other legislation, it's assumed that they exist. And then when it comes to amend by inserting authority for commission, it's simply reflecting the amended position. So that's the and then, Lord, in relation, the same technique is used in relation to the Building Societies Act. See pages 61 and 62 of this bundle, using those same page numbers at the top, and page 82 for the amendment to section 111. And so far as the Industrial and Provident Societies Act 1965 is concerned, see page 91 and page 96. But it's the same point. I hope that's clear, my Lord. Thank you very much, my Lord. So, Lord, may I then just go on to deal finally with some of the points from the oral.
I wonder whether could you just, I'm sorry to trouble you, I don't want to take out, but could you look at divider 15, section 249 of the Banking Act 2009?
Yes.
I mean, I have myself never seen a provision like section 1, subsection 4 of the 2000 Act. I've never seen such a thing. It just, all it does is to tell you what you find in another act. I mean, it's quite extraordinary. I've never seen such a thing. But if one looks at section 249, subsection 1, that says a reference in an enactment to function conferred by or under the 2000 Act includes a reference to functions conferred by or under this Act. Yes?
Yes.
But then the second one, which explains what is meant by that extraordinary phrase, generally or under this Act, it says a reference in an enactment to functions of the financial authority includes a reference to functions conferred by or under this Act, and so on. Now, I mean, what can you explain what exactly is going on?
Well, Lord,
the first one, you see, it refers to the functions under the 2000 Act, and the second one, just is another way, is referring to functions conferred by this, by or under this Act. Is that right? Sorry, functions, a reference in any enactment to functions of the financial authority. So what we're getting at in generally is a reference to subsection 2 of isn't that right?
well, Lord, it may also be feeding into Schedule 1, because Schedule 1 of the Financial Services and Markets Act, which of course is the constitution of the FSA, because that. Well, Lord, may I try to take it in stages first of all? 2491 is effectively saying that the functions conferred on the FSA by the Financial Services and Markets Act is to include references to functions conferred by the Banking Act.
Yeah,
that's the starting point.
So any reference in any enactment to functions conferred.
Yeah. And then 2 is a reference in any enactment to functions of the authority includes to include a reference conferred by the Banking Act.
Yes.
And then if we just go back, my Lord, to the Financial Services and Markets Act, because yes. And may I just pick up page 92 of the bundle, my lord, where the schedule is set out, because this is effectively the constitution of the FSA, and for example, while we're on this, just so that your lordships note the role of the Treasury, paragraph 2.3, chairman and members of the governing body must be appointed and be liable to removal from office by the Treasury. So there's an example of the Treasury. Then paragraph 7, arrangements for the investigation of complaints. That's also overseen by the Treasury. See subparagraph 3. Then annual report is paragraph 10. And paragraph 17 is fees. But importantly, and this may be a clue, part 4 of the schedule contains miscellaneous provisions and deals with the exemption from liability and damages, and that also contains the provision where certain functions are treated as functions done under the Act. So, for example, under paragraph 19, exemption from liability and damages, and 19A is discharge of functions of the authority. So it does appear as though those provisions, or the provision 249, which is a curious provision, I agree, appears to be making sure that there is, so far as the legislation is concerned, a cross-referencing of functions.
Well, as far as I understand it, is where you find in an Act a reference to functions conferred on the financial authority by or under the 2000 Act, then you read it as including a reference to functions under the Banking Act. And equally, where you find an enactment reference simply to the functions of the Financial Services Authority, so not this time to ones conferred under that and so on and so forth, then these also include a reference to the ones under the 2009 Act. Isn't that what it says?
Yes. Yes.
So, I mean, it's just puzzling, or strange to some references being made to it. What is meant by this, whether generally or under this Act, in the most peculiar thing, subsection 4 of subsection 1, it must be a reference to subsection 2.
Well,
Mustn't it? Because if you look at 1.4, all it does is to tell you what you will find if you look in section 249.
yes. I fully accept that, my lord. What we would say, we have two submissions in relation to that. First of all, generally, it has the widest import, and it's not necessarily limited only to the functions under this Act or the Banking Act. But my lord, may I say this, which is perhaps more important? Whatever the position in relation to section 1.4, our argument does not depend upon it. Because if you start from section 1, subsection 1, that is not saying these are all your powers. And nor does this say these are all your powers. And in those circumstances, my lord, because we don't depend upon it, rather than inviting your lordships to write a treatise on everything that's contained in the materials, which we certainly don't invite your lordships to do, we say this case is very simple and straightforward. But
subsection 4 is about the only one I've found simple and straightforward.
But my Lord, it's certainly not the case that our argument depends upon that. But my Lord, if I can find out further information in relation to that, I'll certainly provide it to you.
Could I just ask you this in relation to functions? What is the relationship, if any, between the functions referred to in section 1, subsection 1, and, for example, any functions, if there are any, to be found in the memorandum and articles?
Well, my Lord, the answer to that is actually contained in the articles, the memorandum and articles themselves, because if we actually go to our supplementary bundle where they're set out in order.
We've got them, but not before the Act. We've got them only after the Act, is that right? We have the one before the Act.
We got them before the Act, Lord, because we got the April 2000, which was what it was before it was amended by the special resolution in February 2001. But we looked at that. That's behind.
So tab 2 is pre the Act.
Yes, that's April 2000, my Lord. Then tab 3 is pre the Act, but in contemplation of the Act, because of course the Act hadn't yet been implemented. It had received royal assent, but not yet implemented. But in contemplation of implementation, your Lordship will see that behind tab 3, the second page, where the objects are set out, this was the clause your Lordship will see from footnote 3. Clause 3 was amended by a special resolution passed in February 2001, and the authority's objects are to carry out any functions conferred on the authority by or under any provision of any legislation. So there's the reference to the legislation as amended from time to time, and to carry out such other functions or exercise such powers as from time to time may be carried out or exercised by the authority. And then B is also relevant, to carry out any other function or exercise any other powers may, in the authority's view, assist it or enable it to carry out the functions and powers referred to above, or which the authority considers incidental, desirable, or expedient. So Lord, that's recognising the statutory functions, but it's also saying that you can do anything which in the authority's view assist it or enable it to carry out the functions, or which the authority considers incidental, desirable, or expedient.
And does that replace tab 2?
Yes. It replaces... Yes, it does, in relation to the objects.
So instead of having all the objects set out in detail, we now just have those two objects.
Yes, that's right, my Lord. And then we then...
So we no longer have the reference, relevant or otherwise, to instituting proceedings and so on.
Yes, that's right, my Lord. That's right. And then, my Lord, if we go on behind tab 4, this is... the 6th of February 2006 edition. That date can be picked up by the company's house stamp on the first page, but this is the current version, and it's got those broad objects. So that's the position, my Lord. Lord, may I just deal then with some points from the oral submissions. First of all, the explanatory notes. We say they add nothing to the argument and may actually be misleading and should be approached with care. And the danger is, which is always the danger, of looking at extraneous materials. It involves, we're concerned with an exercise of construing section 401, 402, not construing the explanatory notes, and that would be...
I mean, it does look as if the draftsman was under a pretty basic misapprehension. doesn't it? Or is that putting it high?
My Lord, as Lord Nichols said in the Sparthome case, people's understanding may be woefully inadequate, or it may be it may be disappointingly misleading. But what we're concerned with is what Parliament intended, and we shouldn't be.
Where is this? Where are these? No, we've got them in this other thing, haven't we?
And they're also in Provider 10, Lord.
Yeah.
And, Lord, it's significant, we would submit, that yesterday a concession was made, although it appears as though it was later withdrawn, but a concession was made that the authority did have, or had had the power to prosecute offences of insider dealing before December 2001, and we submit that the concession was properly made and is destructive of the arguments. Lord, there is one other matter that I ought to draw to your Lordship's attention in relation to the Money Laundering Regulations 2003, which your Lordships have not seen, because it also sheds light on the role of the Treasury. But we've provided to your Lordships the Money Laundering Regulations 2003, and I hope your Lordships have them. And if I may just take your Lordships to Regulation 1 first of all.
Where are we going now?
There should be your Lordships should have, I hope, these 2003 regulations. And Lord, it's just to deal with the point that was raised yesterday, my Lord, about what was the position under these regulations. And your Lordships will see from Regulation 1 that they are, but by Regulation 1, Paragraph 3, the regulations are prescribed, and it's also necessary to look at the interpretation Regulation 2, which on page 5 of 35, using the page numbers at the top, defines the commissioners as meaning the commissioners of customs and excise. And then, if I may just go to Regulation 23, which is the prosecution provision. It's the prosecution of offences by the commissioners, and it says proceedings for an offence under these regulations may be instituted by order of the commissioners. Such proceedings may be instituted only against an operator or high-value dealer, or where such person is a body corporate, a partnership, etc. 3, any such proceedings which are so instituted must be commenced in the name of an officer. Then it says if an officer dies, it doesn't have any impact on the proceedings. And then 5, where the commissioners investigate or propose to investigate any matter with a view to determining whether there's been an offence, it's to be treated as an assigned matter within the Customs and Excise Act. And then 6, in exercising their powers to institute proceedings for an offence under these regulations, the commissioners must comply with any condition or restriction imposed in writing by the Treasury. So there's the same provision, but the purpose of this submission is to demonstrate that the commissioners are not being told you can only prosecute under these regulations. So it's just to make good that point, my Lord. Lord, what's...
Sorry, I'm completely lost. Are you saying your people could or couldn't prosecute under these?
But Lord, what I would say is we could, because of 402 1B. They're designated, so we could. But it doesn't look like anyone else could, except the commissioners. But what's interesting about these provisions, we don't need to construe these, but what's interesting about Regulation 23 is it doesn't say anything about Scotland. That's why earlier I suggested that in Scotland the commissioners do have a power to prosecute. So that looks like it's the position. So it's just simply to make good that point, Lord, and it's not necessary to go through anything else in those. May I just give your Lordship a reference about where these offences you have to take into account guidance approved by the Treasury, which may explain also the control by the Treasury. See Regulation 3, paragraph 3, where it deals with whether, in deciding whether a person has committed an offence, the court must consider whether he's followed any relevant guidance issued by a supervisory authority or any appropriate body, approved by the Treasury and published in a manner approved by the Treasury. So there's another example of the Treasury's role. And the same position applies under the 2007 money laundering regulations. There's reference to the Treasury in I believe it's Regulation 44, but it's for your Lordship's note, it's divider 20 of the bundle, and it's actually Regulation 45(2) for the guidance approved by the Treasury. That's just again. Lord, may I just say something about the indictment and the point that was made yesterday about whether it would necessarily be the case that an acquittal of insider dealing would lead to an acquittal of money laundering, Lord. I'm not familiar with the evidence available in this particular case. Mr. Grodzinski and I do not have the conduct of the prosecution, but, Lord, it would not necessarily be the case that an acquittal of a substantive offence would lead to the acquittal of a money laundering offence, because, of course, a jury may conclude that an accused person was not, in fact, involved in the substantive or the predicate offence, but nevertheless handled the proceeds of crime. The proceeds that were handled were nevertheless the proceeds of crime. But Lords, in any event, these proceedings raised an important point of principle so far as the authority is concerned, and lest your Lordships think that it's not important, it may have some historical importance, because there are previous cases in which people have pleaded guilty to to offences outside the Financial Services and Markets Act. And therefore, if it were to transpire that the authority did not have power to prosecute, then a question would arise as to whether the convictions in those cases...
You say you prosecuted previously for conspiracy. I mean, were they pleas of guilty or...
may I just check in relation to... I'm sorry, my Lord, I just... the only guilty pleas, the only guilty pleas, my Lord, I understand have been...
There were guilty pleas.
The guilty pleas to theft and forgery, my Lord, rather than conspiracy. The guilty pleas have been returned in relation to theft and forgery. So there are...
You were telling us there'd been earlier prosecution for conspiracy.
But they weren't guilty pleas, my Lord.
No, I mean, I'm not sure why it matters terribly whether they were guilty pleas or not. But...
I'll try and find out.
Well, I don't know. Why does it matter as a matter of interest?
Well, my Lord, it matters in as much as... we would not like it to be thought, my Lord, that...
Zolinter or Emperor.
No, my Lord. No, my Lord. The point that was being made yesterday was really, have the FSA overloaded the indictment, and are we here looking at this case when they could have just gone for insider dealing offences? And the submission that we make is there is an important point of principle here, and of course it matters to the authority as to whether it has power, and also there are these other cases in which...
in which people have been found or pleaded guilty. I can't see why it matters which it is.
Yes. Okay. Lord, so far as the symmetry argument in relation to injunctions is concerned, we make the same point in relation to the symmetry argument in relation to investigations. A power to prosecute does not depend upon either investigative powers or a power to obtain an injunction. And Lord, subject to any questions that your lordships may have, those would be the submissions on behalf of the respondent.
Thank you very much. Mr. Grodinski. Yes, Mr. Miskin.
May I take up just a short amount of time with your lordships by way of reply? As a matter of fact, in this case, the indictment against Neil Rollins charges him, as your lordships know, with insider dealing and with transferring criminal property. But of course, the criminal property in this case is that which represents the proceeds of his own alleged insider dealing. So it really adds very little indeed. It may, I suppose it's not unfortunate for the Financial Services Authority that they happen to have chosen to pick a fight with a man who's a middle manager in a small northern firm rather than facing a major bank with the same arguments of money laundering and insider dealing. But there we are, that's the situation. My lords, can I just deal with, first of all, prosecutions and this presumption that anyone may prosecute, and that must mean that everyone may institute proceedings. And of course, to an extent, that is obviously true. There are substantial limitations, however, on that truth. The first of the matter is that corporations created by statute are limited to prosecuting those offences either specified in the enabling statute or within the functions conferred. Local governments, for example, are amongst those. And, of course, in the Security Plan case, a case which was a rather curious one, and my own friend Mr. Perry was in it, they managed to get to the divisional court, notwithstanding that the matter related to a trial on indictment. And although the divisional court decided to refuse permission because they held that they had no jurisdiction, and also on grounds of delay, nonetheless they gave an opinion about the statute. And they reached the conclusion that the functions conferred by the statute were wide enough to support the ability of the authority to prosecute for the specified offences in enhancement of their functions as a regulator. In relation to private corporations, that is to say, by which I mean non-statutory corporations, the case of Gladstone is before your lordships, and I'd be grateful if we could just look at it very briefly. It is actually at tab 6. And this was the case where there's an annual general meeting where the chairman was assaulted, and the company decided to attempt to prosecute. In the judgment of Mr. Justice Leveson, as he then was, at paragraph 12, he refers to companies subject to varies seek to protect their staff from violence are perfectly entitled to commence a prosecution in the event of the police declining to do so. Is there a difference here? In my judgment, there is not, although I suspect, my lords, that the nature of the prosecution was that of laying information by the aggrieved and then supported by the bus company itself. And then going on to paragraph 30, turning from the general to the specific, that organisations may be set up specifically to coordinate prosecutions, does not go to whether the organisation can prosecute, which, as I say, depends upon the public interest involved, but rather to the varies of the authority vested in the company. And the varies of Gladstone plc was set out there, immediately below. Paraphrasing, the company has within its objects the power to manage and control the operation of any company and do anything which may be considered conducive to attaining that end. The operation of the company includes complying with its statutory obligations to hold annual meetings, and it's beyond argument that to do so includes the ability to control order at that meeting. Of course, such control must be balanced in such ways to ensure for all and every shareholder the legitimate right to participate. And then he goes on to say, in my judgment, the company does have the power potentially to institute a prosecution and sufficient interest in the circumstances of this case to do so. Whether, as Mr. Nichols for the claimant now argues, any person could institute a prosecution is not a matter which necessarily falls for decision in this case, and I prefer to say no more about it. Much energy here before the district judge, and indeed the written submissions before this court, has been directed as to whether the company has the power to lay in information, in particular as to whether Rubin and the director, to which he previously referred, Lord Justice Watkins, was correct to include that section. Well, I've addressed you on that, so I don't propose to repeat that. He said, in my judgment, it's unnecessary to enter into this debate. In this case, an information was not laid by a company, but rather by Mr. Bradley Lee, a solicitor with the firm instructed by Gladstone. Over the page, my Lord, is Lord Justice Rose's judgment, who said, I agree. On any view, criminal proceedings by a public company rather than the police against a shareholder for alleged assault on a director in the course of an annual general meeting are very rare indeed, and certainly out with my 50 years' experience in relation to the criminal law. The evidence in relation to the alleged assault is not before this court. Accordingly, I have no view one way or another as to the merits of the allegation. Clearly, a public company is entitled to take proper steps to ensure that its annual general meeting is conducted in an orderly fashion. Equally clear, it's the right of the shareholder to make known his or her views. In the present case, it would be lamentable if the board were seeking to suppress a legitimate, albeit hostile, comment on their performance by having recourse to criminal process. Now, this is the only authority which I think the combined efforts have all been able to identify as being a prosecution, so to speak, by a non-statutory private corporation, and that is the state of the law. In relation to the Director of Public Prosecutions, can I just say a word about his role, please? My Lords. And the best place to start is within the statutory materials in tab 2. The director, as an office holder, of course, was created back in the 1880s or 90s, I can't quite remember when, but 1887, thank you very much indeed. He generally took over prosecutions instituted by others, particularly in murder and other serious cases. And he was granted over many years the power to consent. There was a requisite in power imposed on many statutes which required his consent to prosecute. His position is under Section 1 of the Crown Prosecution Service. And of course, he was never in reality a public prosecutor because he had no power to direct the police or chief officers of the police to institute proceedings. The Crown Prosecution Service under Section 1 is a prosecuting service that consists of the director, who should be the head of the service, the chief Crown prosecutors, and other staff. And then it's important, it's rather all over the place, my Lords, but would your Lordships go, please, in the other bundle, this bundle that looks like this. To page 7. Under Section 2, he's appointed by the Attorney General. He must be qualified in a certain way. And his functions are, as set out in Section 3, the Director shall discharge his functions under this or any other enactment under the Superintendence of the Attorney General. It shall be the duty of the Director, subject to various provisions by the Director of the Serious Fraud Office, to take over the conduct of all proceedings other than specified proceedings instituted on behalf of a police force, whether by a member of that force or by any other person, to take over the conduct of any criminal proceedings instituted by an immigration officer, and then be to institute and have the conduct of criminal proceedings in any case where it appears to him that, and there are a series of sections set out which impose upon him the duty to institute proceedings in a variety of circumstances. And what I tentatively derive from that, although the words are expressed as a duty as opposed to a power, what I tentatively derive from that is that when one looks at section 401, by way of example, which I just reminded, I think if it's tab 10, yes, thank you very much indeed, tab 10. And page 88. It says that section 401(1) in this section, offence means an offence under this Act or subordinate legislation made under this Act. Proceedings for an offence may be instituted in England and Wales only, A, by the authority or the Secretary of State, or B, by or with the consent of the Director of Public Prosecutions. And it's my submission that that empowered the Director of Public Prosecutions, in part, or partly did this, to institute proceedings. Not just to take them over when they've been instituted by others, but to institute them himself, or herself, as it's been in the past. And that if one looks at the way in which the Court of Appeal put it, that they were right. It's in core volume divider 5. At paragraph 23. We accept that section 401 is apt to confer an express power on the persons named in it to institute proceedings for offences under the Act or subordinate legislation made under the Act. And the court in Ubroy held in terms that the FSA was empowered by subsection 2 to institute such proceedings. In our judgment, however, the essential purpose of the section is not to confer power, but to limit the persons who may institute proceedings for offences under the Act or subordinate legislation made under the Act. And we rely on that passage because we submit that that the operation of this section is twofold, both to confer power and to limit its use. Turning now to section 4.
I'm terribly sorry. So you're saying what? That until 401, the Director couldn't prosecute under this legislation?
Well, my Lord, this legislation created new provisions, brand new provisions. And what this section does is that it creates those provisions. This section confers the power to institute them upon a limited class of persons. A closed class of persons by use of the word only.
Well, it's fairly broad in one theoretical sense because it applies to anybody who can get the consent of the DPP.
Theoretically, but consent is different to institution.
Of course, no, I understand that. Yes, but it's not terribly closed.
Of course, I agree with that, my Lord, but in practice, it is.
Well, there are three responsible bodies: the authority, the Secretary of State, and the Director of Public Prosecutions.
Yes, Lord. All of whom are empowered to institute these proceedings as public bodies. Alternatively, as to some, to consent to others to institute. So as to the authority of the Secretary of the State, they may institute them only. They may institute them. As to the Director, he can institute, but he can also consent to the institution by others.
But I mean, if there hadn't been a section 401, there's still an awful lot of offences created by the Act, and the Director could perfectly well have instituted proceedings, couldn't he?
So could Uncle Tom Cobley and all.
Well, my lord, that...
The Crown Prosecution Service,
Yes.
for whom he's ultimately responsible, would have taken these proceedings.
Well, one has to imagine the circumstances in which that would have been done. He's under a duty, my lord, as your lordship, of course, well knows, to take over the proceedings instituted by a police force. Of course, there have been very recent amendments to the Police and Criminal Evidence Act under Section 39 to enable him not just to give guidance, but actually give advice as to how the police should charge. And those sections are also in our bundle, the bundle we've had open just a moment ago. Up until then, he had no power to direct a police officer to institute proceedings. And therefore, query, did he have power to institute these proceedings? My own defence case is that he does. My submission is that it is not as clear-cut as it might seem.
So is it your submission he doesn't, or didn't, or wouldn't have?
My lord, that depends on the functions that are established in Section 3 of the Prosecution of Offences Act. Those are his functions.
One of
And he's got
which is to institute proceedings if he thinks it's appropriate to do so.
If he thinks it's appropriate to do so, yes. But subject to that. And within a certain class of category.
Where in all the world did the poor Lord Advocate get her power to institute proceedings?
Well, the history of the Office of Lord Advocate in Scotland is extremely different to the history of the Office of Director of Public Prosecutions in England and Wales.
Not a word is said in Section 401 or 402 about the Lord Advocate having been given power to prosecute. Yet, that she has the power, there isn't the slightest doubt. And it's because that's just that the legislation is framed on the basis against the general law relating to prosecutorial powers, which, as I understand, is Mr. Perry's basic point.
Yes. But, I mean, if one takes some of the minor offences under the Act, it is very open to doubt, my lord, whether or not it would be the function of the Director of Public Prosecutions to institute proceedings in relation to them. Because it simply would not come within his general functions.
Well, it might do, depending on the facts of the case.
Well, of course, but he has, as the Financial Service Authorities has conferred with certain functions, so is the Director, and he has to comply with those functions. If he does not believe that the offence falls within Section 3(2)(b), namely that the importance or difficulty of the case makes it appropriate that proceedings should be instituted by him, or it is otherwise appropriate for proceedings to be instituted by him, it would be out with his functions to institute them.
He wouldn't have a duty to do so.
That's his duty, yes. Be that as it may, Lord, it's my submission that the Court of Appeal were right about the way in which they expressed themselves in relation to Section 401. Well, in relation to section 402, shortly, and again looking at tab 10 and page 88. Candidly, the suggestion that section 402(1)b was passed in contemplation of a closure of a class of prosecutors sometime in the future is fanciful. There are simply no grounds for suggesting that such was in the contemplation of the legislation. Indeed, if I may once again call the explanatory notes to my aid, and I do for these purposes, if you'd be good enough to go within tab 10 to page 114, paragraph 712, this section allows the authority to prosecute in England, Wales or Northern Ireland 2 criminal offences which are not in this Act. They are offences of insider dealing, Part 5 of the Criminal Justice Act 1993, and breach of the money laundering regulations 1993 Regulation 5. So the regulations in the contemplation of Parliament at that time were the extant regulations, not some future regulations which might create a closed class of prosecutors. It's my submission that the 2003 regulations do not, and I think it's only hesitantly suggested, create a closed class of prosecutors. It's only 7 years later than 2007 that such a closed class is created. And if we're right about that, and the Court of Appeal are wrong about that, and my learned friends who appear for the Financial Services Authority are wrong about that, what role does section 402(1)b play when seen together with 402(1)c as well? What is the significance of these sections? It's not in our submission sufficiently to say that it represents legislative untidiness. Yes, of course, the draftsman may occasionally fall into error. But these provisions have the look, do they not, of careful drafting. They are juxtaposed with section 401. What do they mean? Unless the suggestion by my Lord Brown is germane to this issue. But with respect,
not my suggestion. I mean, it's Mr. Perry's suggestion.
Well, Mr. Perry, can I take it up like that? Look, if there is anything in that suggestion, would it not have been easier to redraft the section in rather more intelligible terms? Something along the lines that in exercising its power to institute proceedings for the following offences, the authority must comply with any conditions or restrictions, so as to headline the importance of the Treasury function in relation to the selection of that class of offences.
But I mean, if Uberoy is right, you still need A.
If Uberoy is right, you still need A as a disapplication of the consent provision.
Exactly.
But, well, again, I don't wish to go round and round, but Uberoy didn't consider B and C.
Well, I think we've been around that garden quite a few times.
My Lord, yes. In relation to the issue of the deeming provisions, may I respectfully adopt the reasoning of Lord Roger in relation to section 249 of the Banking Act. In relation to the predecessor statutes in relation to the mutual societies, we simply submit that Mr. Perry is simply incorrect. If one looks at Article 4.2 and Para 2 of Schedule 2, all functions save legislative functions of those societies were transferred to the Financial Services Authority. And one of those functions must have been that of a prosecutor for offences under the various predecessor acts. It must have been so. And in our submission, if that is the case, and leaving aside the two other minor exceptions, both of which appear under statutory instruments made much, much later, the payment service regulations and the private or the accredited financial investigators. That aside, it is our submission that clearly the powers of the FSA are derived exclusively from the Financial Services and Markets Act. What other purpose are the principal deeming provisions, including Section 249 of the Banking Act? What other purpose do the other deeming provisions have in the various sections that I mentioned, in other primary legislation? Is this position to be disturbed by references in the 2009 statutory instrument which granted the Rural Payments Agency, amongst other things, a role as an accredited financial investigator? Moreover, and we'd like to, if we may, just to perhaps send in something in writing about this, we have since discovered that there are certain deeming provisions within the payment regulations as well, which relate to fees and so forth and so on. And those regulations are 92 and 94. Lastly, in relation to the symmetry point, it was a little unfair of Mr. Perry to say that this had not so far been mentioned in relation to the private investigators, as indeed it is set out in our case at 13.7. I want to just go to that, please. And if I could just quickly run through just that paragraph. Central to the structure of the Proceeds of Crime Act, POCA, are the powers, duties and liabilities specified public prosecuting authorities and officers. It was plainly never contemplated when POCA was enacted that the FSA would prosecute money laundering offences, and permitted to do so would circumvent the safeguards built into POCA.
We will be looking at this. Is there any need to read it out to us?
Well, my Lords, no, it's just that we haven't visited this at all before. I'm quite content to leave it as such. But I would.
Well, I think you can rely on us to read your written case as well as listening to your submissions.
I just wish to
and
highlight
indeed that
the point.
of your opponent.
Yes, of course. In this regard, also, my Lord, to go through to on page 22, letter I. My Lord, I'll just finish, if I may, like this. It's interesting to note on page 346 of the authorities bundle. Sorry, the legislative bundle.
POCA order.
Yes, the POCA order. Pink volume, Statutory Materials 346. That at least in note 4, that the writer of explanatory notes is at least consistent in his view of the Financial Services Act, in that he says that the Financial Services Authority's powers are contained in the Financial Services and Markets Act 2000. Lord, I'm very grateful.
I'd just like to ask you one question on one of the points Mr. Perry made. He's made a number of points in relation to provisions about time limits for commencement of proceedings. One is the Building Societies Act, 1968, which appears to contemplate that the FSA had powers to prosecute outside the FMSA. And what do you say to that?
Well, my Lord, we would say, first of all, it's just subject to the deeming provision in any event, that the powers are transferred to the FSA by virtue of the Order of 2000, which is made under the Principal Act. Those are its powers. Without that deeming provision, it couldn't have done it. Thank you very much, Lord.
Well, we're grateful to all counsel for their submissions. We will take time to consider our judgment in this matter.